Court is calling 2025 CR 007442 State versus Ezra Espinoza. Could I have parties announced for the record?
In gallery for the state.
Patrick Claus for the defense.
And you're Ezra Espinoza?
Yes, ma'am.
All right, so Mr. Espinoza, my understanding, your agreed restitution is $5,000 and you're paying $900 today, is that correct?
That's correct.
All right, and are you currently employed?
Yes, ma'am.
What do you do?
I work for a tree company.
All right, and is there some sort of light season for that work, or is it always steady?
It's not steady. Every day we do look for work, but there's some days we don't get work. So I get paid often.
All right. I know usually when they have brush pickup, that's when
Yeah.
the work is a lot. So how far did you go in school?
The ninth grade.
So do you have your GED or anything of that nature?
No, I do not.
So what is your dream job? What are you planning on doing with the rest of your life?
I'm a businessman.
Well, how are you going to do that? I mean, we can say, people always say, put things out in the universe and it will happen, but you have to have a business plan. So what are you going to be doing?
I couldn't tell you that, but that's for you asked me what I wanted to be. So
Yeah. I mean, yeah, but I mean, you say a businessman, but a business in what? And business school, they would say, all right, we're gonna do this fake company and we're gonna sell widgets. So what are you going to be selling? Are you gonna be selling everything? Or are you just gonna be a hedge fund person?
I don't know yet.
See, that's the thing. You're 20 years old, you have a criminal case. You need to start coming up with plans and not just saying, I want to do this, and you're not doing anything to work towards that. So you live at home?
Yes, ma'am.
No children? Don't have any children until you have your life in order. You understand?
Yes, ma'am.
All right. This is what the court is going to do. And state, you may be excused.
Thank you, Judge.
There's a $2,000 fine that's going to be probated. 3 years deferred adjudication. There is restitution to Clara Valle, Valles, of $5,000. The court will note that the defendant has already made a payment or is going to make a payment of $900. So that would leave a balance of $4,100. There's the regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits 1 time per month for 6 months. There's going to be 160 hours of community service restitution. 100 of those hours will be deemed satisfied upon completion of your GED. And probation, I'm ordering that he get his GED. And the remaining 60 hours will be waived upon completion of some type of trade school certification or a higher level of education. So this is the way this works. You must obtain your GED. Once you obtain the GED, 100 hours of those will be waived. The remaining 60 hours of your community service restitution, you can do that, work in the hot sun, or you can do something to improve yourself by either getting some higher level of education or your trade school certification in whatever you want to get it in. You understand? Probation, is there anything else? All right, this is running concurrently with 2024 CC 73745. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand.
All right, we can go off the record. So here's the thing. You are on deferred adjudication. It's a deferred adjudication for a felony. The felony that you're on deferred adjudication for is what's called a crime of moral turpitude. So that's gonna put some stumbling blocks in your way, but you can still be successful. I know people who have been through felony drug court. They've had crimes of moral turpitude on their record, but guess what? They turned their life around and they're now attorneys. They turned their life around and now they're doctors. So this is not the end of your life because you have this case. Because sometimes employers will look at that and they would say you were young, you didn't know any better, and they'll overlook it. But you're gonna have to do your part, okay?
Okay.
Make sure you communicate with probation. And here's the thing, you're on deferred adjudication. Everything that you do from here on out, you need to ask yourself, could this potentially result in me going to the state jail facility for 2 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. And when you do state jail felony time, that's day for day. So if you were to get 2 years, you'd be there for 2 years. You understand?
I understand, Your Honor.
All right, make sure you communicate with probation. If you feel they're not addressing it, you can always come back and address it with me, all right?
Okay.
All right, good luck to you.
Thank you.
Oh, one other thing, how much money are you gonna be paying per month?
I can comfortably pay 300.
All right, and Miss Abrams, he's gonna pay 300 per month towards restitution. And if for some reason there's an issue with him, you need to let them know.
Okay.
All right, good luck to you, okay?
Thank you.
You're welcome. And thank you for dressing appropriately for court. All right, probation, this is an application. The court is calling 2025 CR 003287, State versus Christopher Vincent White. Can I have parties announce?
Rick Pena for the state of Texas.
Doug Campbell for Mr. White.
And are you Mr. White?
Yes, Your Honor.
Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. White, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, we will waive the repeat offender enhancement.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with assault family household member with a previous conviction as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a U.S. citizen, by entering into this plea, you could be deported, not
Yes.
allowed re-entry or naturalization?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Lenea, Lenea, Laralde, Larralde. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge. With
State-
one change,
Yes.
believe Ms. Rinaldi now goes by Ms. Bland.
I'm sorry, the last name?
Last name Bland,
BLAND?
B-A-L-A-N-D. B-L-A-N-D, yes.
All right. State, is that the plea?
That is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 100 hours community service restitution, the BIPP, cap evaluation, and follow all recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers into evidence, State Exhibit 1 with all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. So, with regards to this plea bargain, I don't see why I should follow the no harmful or injurious contact. Why shouldn't it just be no contact?
I can address that.
Yes.
Mr. White and Ms. Bland, who's sitting here in the front row, have had a conversation while Mr. White was in prison for the previous family violence charge.
And the previous family violence charge, was that against her?
No.
I could, no.
Okay.
But I think that change of heart has led them to understand that this is not the path that they both want to go down. They are going to raise a couple of children together, and if there's a no contact order, that's going to be a cost to them.
What, are these his biological children?
They are not. They're children that she has adopted. Her biological.
Wait, let's slow a bit. So she's adopted some children. I'm reading this police report that she had been living in a hotel from hotel with these adopted children.
Don't believe they were there.
They were not adopted at that point.
Well, that's true.
So she didn't have any children with her at that point.
She may have, Judge. I think the difference, though, is that having served his time, Mr. White and Ms. Bland are asking the court to allow them to have no harmful or injurious contact. He is on probation still for the other case.
Parole.
Parole, excuse me.
Yeah, I don't think this is a good. I'm not going to follow the no harmful or injurious contact.
I talked to my client briefly.
Sure.
Judge, in talking with my client and with Ms. Bland, they are okay with no contact.
All right, because here's the thing, you have to internalize what you did. You have someone who's living in hotel from hotel.
I was living
They're
with-
telling you, no, according to the police report, she's telling you, you can't stay with me. And I'm making an assumption that she didn't want you to stay with her because you were not pulling your weight, because she's living in a hotel. And then you come over anyway with your clothes, and then you hit her in the face with a Nike sandal. That's what the police report says. And she had visible redness. So it appears to the court, you haven't learned anything from being in prison beforehand or being on probation beforehand with the
Judge,
previous assault.
this was before he went.
This was previously before I've been incarcerated. I've been incarcerated for 1.5 years since then.
I don't think your relationship with her would be a good one. And I don't think you would be successful on probation with that relationship.
That is-
And I don't think adopted children need to be around that. So it's
And
any objections? I've heard your argument. what I can tell you, your plea bargain agreement is for no harmful or injurious contact with Linnea. I am actually going to do a no contact order with her. So that is a violation of your plea bargain agreement. So do you still wish to go forward with this plea?
How long would it take to get a trial?
How long, what?
How long would it take to get a trial set?
Oh, we can do it right away.
Ready?
So,
Right now?
Probably gonna be next week.
So just go,
so what do you want to do?
just go with the no contact. It's fine.
All right, so there's a $1,500 fine that will be probated. There's an affirmative finding of family violence. There's to be no contact.
Judge, with
Yes.
respect to the TAP evaluation, given the fact that he's been locked up for a year and a half, can you do that without?
Let me get to that. Just give me a moment. So there's to be no contact with Linnea, Laraldi, Bland. Proof of employment within 45 days, no employment as a home healthcare provider or with minors, no residing with minors. The BIPP course, 100 hours of community service restitution, TAP evaluation, out of custody, follow recommendations. If you miss that TAP evaluation appointment, that's going to be a violation of your probation, you understand?
Yes, Your Honor.
Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person, regular random UAs.
One other thing,
Yes.
with respect to the requirement for employment, my client does have a disability. That's-
All right, so what's your disability?
I'm MHMR, I have bipolar, PTSD, I have
All right.
ADHD. When I have a stipulation on my parole that I have to go to special needs program, so I'll be having to do programs for that.
All right, so it's going to be proof of employment within 45 days or SSI within 45 days. MIC evaluation, out of custody and referral for Center for Healthcare Services. Probation, is there anything else? Is there anything?
The length of deferred, Your Honor?
Oh, thank you. 3 years.
I'm sorry, Judge.
No, it's my fault. 3 years deferred adjudication.
Judge, our agreement was 2. We just.
No, that's not a part of the agreement.
Discuss it.
It's fine.
Sure.
Okay, sir, I'm just.
All right, 3 years deferred adjudication. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, sir.
Thank you.
Thank you. And are you Mr. Gutierrez?
John?
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, John.
Are you the same Ricardo Gutierrez who was placed on deferred adjudication in 2024 CR 6357 for the offense of theft of property less than $1,500 with 2 or more previous convictions on August 5th, 2024 for a period of 2 years? Is that you?
Yes, that's correct. Your Honor. Yes.
All right. State?
Violated condition number 2, on or about the 5th day of April 2025 in Bexar County, Texas, the defendant Ricardo Gutierrez did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you think to that? True or not true?
True.
Violated condition number 2, on or about the 6th day of February 2025 in Bexar County, Texas, the defendant Ricardo Gutierrez did then and there illegally use a controlled substance, namely opiates, in violation of condition number 2.
That is true.
And finally, violated condition number 20, On or about the sixth day of May, 2025, in Bear County, Texas, the defendant Ricardo Gutierrez did then and there fail to register for/attend a theft program with the approved agency in violation of condition number 20.
How do you plead to that? True or not true?
True.
And state, do you waive the remaining violations?
Yes, Your Honor, state waives the remaining.
Any objection?
No objections.
All right, did you understand by pleading true to violations 2, 2, and 20, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations 2, 2, and 20?
Yes, Your Honor.
And do you have any objections to this attorney standing in because it's listed as Ernest Acevedo III?
He can stand in, yes, it's fine.
All right, is there a proposed agreement?
No, Your Honor, but the state's recommendation is to revoke community supervision and sentence to 9 months in the state jail facility.
All right, in defense, what are you requesting?
Judge, we are also asking for revocations. The motion be granted, but we are asking the court would consider giving him credit for time served under 1244 and satisfying his judgment. He has 126 days credit in the Bear County Jail. He was picked up on a drug charge. However, Judge, that case has been dismissed. It was part of the allegations in the NTR, but obviously because of the dismissal, the state's not proceeding on those. Because of that, he's been waiting on this MTR, and at this point, that's what he's asking for, Judge. He knows he's made mistakes, and that's why he's pled true on those, and he's going to take responsibility. But we just feel that he has served time for this, asking to satisfy that.
What has he done on probation?
Judge, he has done a parenting class, right?
I did a parenting class. I
Did
made
you complete the parenting class?
yes, and that
Can you raise your
completed
right hand for me?
that completed 100 hours.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Ricardo Gutierrez Jr.
All right, so what have you done?
I completed a parenting class, and it was one of the 3 classes that I was supposed to be completing. I did 100 hours of community service, and I made several payments to the probation every time I went to my probation appointments on time.
Did you do the CATs 1 and 2?
I had a year left to complete those. I was saving up money for those. They were $160 each, and I was working on that.
All right, in probation, do you have any documentation?
Judge, do have the parenting classes been complete?
Okay. All right, state.
Your Honor, we would just ask that you sentence to 9 months. The defendant failed to complete the class that was most relevant to this offense, which is the theft courses. Additionally, he does have some prior convictions. We would just ask the court sentence to 9 months.
All right, this is what the court is going to do. The court is going to find you guilty, revoke. Court will sentence you to 9 months in the state jail facility, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. And as part of your conditions of probation, there was a no contact with Walmart. So the court is going to include a no contact order with Walmart. All right, good luck to you, sir.
Thank you, Judge.
Thank you.
All right, let's talk about that. This Texas docket gave us 3 very different stories, each a reminder of how deferred adjudication, probation, and revocation hearings play out in real time. Judge Ferguson presided with her trademark blend of directness, pragmatism, and the occasional life lesson for young defendants was Ezra Espinosa, just 20 years old and already facing a felony case. He agreed to pay $5,000 restitution, starting with $900 that day. When asked about his long-term plans, he said he wanted to be a businessman, though he couldn't say in what field. Judge Ferguson pushed back gently but firmly, pointing out that vague dreams don't work without a plan. His sentence reflected that theme: 3 years of deferred adjudication, a $2,000 fine probated, and 160 hours of community service that could be reduced if he earned his GED and pursued trade or higher education. It was tough love with a practical twist. Use your sentence to build your future or spend it sweating in the sun. Next, Vincent White, charged with assault of a household member with a prior conviction. He applied for deferred adjudication, with both sides recommending 2 years of probation, community service, and counseling. The sticking point was a proposed no harmful contact order with the complainant, Linnea Bland, with whom White hoped to raise children. Judge Ferguson wasn't convinced. Reading from the police report, she noted visible injuries from him hitting her with a sandal and pointed out that his prior record suggested he hadn't learned from past mistakes. She overrode the negotiated no-harm condition and imposed a full no-contact order instead. White hesitated, asking how long it would take to get a trial, but eventually accepted the deal with that stricter term. He received 3 years of deferred adjudication, community service, and treatment requirements, plus strict employment or SSI documentation. The judge's message was unmistakable. Family violence cases won't be minimized on her watch. Finally, Ricardo Gu motioned to revoke his deferred adjudication on a theft case. He admitted to multiple violations, failing drug tests, using opiates, and skipping a theft education program. His attorney argued for credit for 126 days already served, highlighting his completed parenting class, community service, and partial payments toward probation fees. Gutierrez himself admitted he couldn't afford the required theft courses, but insisted he'd been trying. The prosecutor countered that the missed class went to the heart of his original offense. Judge Ferguson revoked his probation, sentenced him to 9 months in a state jail facility, and imposed a no-contact order with Walmart, where the theft had occurred. It was a sober reminder that partial compliance isn't enough if the key terms of probation are ignored. The atmosphere across these but serious. Espinosa's case carried a note of hope, White's underscored the judge's unwillingness to compromise on violence, and Gutierrez's highlighted the consequences of falling short on probation. Judge Ferguson managed all three with clarity and firmness, keeping the proceedings respectful but driving home the central theme: choices matter, and accountability is non-negotiable.